Thank you everyone for attending today's session, Alcohol and Drugs in the Canadian Workplace. Today's session will run about 30 minutes with time at the end to answer questions. Please post any questions in the chat box below. Any unanswered questions will be answered offline after today's session. We have received a tremendous response to this webinar and we are hosting a large audience. If you experience technical difficulties, we suggest you exit the meeting and re-enter it using the link provided in the email. Rest assured that LexisNexis will distribute a recording of today's session in a follow-up email. Now we will meet today's presenter. I am your moderator for today, Monica Sorensen. I am the print marketing manager here at LexisNexis Canada. Our speaker for today is Norm Keith, senior partner at Fasken. Norm practices labor, employment, human rights, environmental, regulatory, business crime, and constitutional litigation. He has extensive experience in advising and representing organizations in matters involving alcohol and drugs in the workplace, harassment, sexual harassment, and violence in the workplace. He is a trusted advisor to corporate boards, executives, and senior managers regarding LEHR risk management. Norm is the leading occupational health and safety lawyer in Canada and has successfully defended more than 1,000 OHS, workers' compensation, environmental, regulatory, and criminal charges. Let's get started on today's webinar. Over to you, Norm.
Thank you very much, Monica, and thank you for LexisNexis for supporting and sponsoring this webinar. We're going to go through a lot of material quickly today, so just a brief introduction. Some people ask what a CRSP is, a CRSP. Well, that's, pardon me, that's a Canadian registered safety professional. Back in 1998, after I'd established myself by writing 2 books on health and safety law in Canada, I realized there was more to health and safety and prevention than simply the law, pardon me. So I found out about this designation and became the first practicing lawyer in Canada to write the exam and pass the Canadian Registered Safety Professional. And so what myself and other of my colleagues do at Faskins is, yes, give legal advice, yes, represent employers in every type of management side, labor and employment and regulatory enforcement activity, but we also like to help clients proactively. So for example, yesterday we gave a seminar on the new federal regulations for harassment and violence in the workplace. So I'm really passionate about helping employers make a safe workplace and manage a good workplace for their employees across Canada. So let's get right into the material then. What we, there's the bio, we can skip past that. Oh yeah, I wrote a book. Actually, I wrote 12 books, and this is the 3rd edition of Alcohol and Drugs in the Canadian Workplace. I want to give a brief shout out, as the kids say, to Ilsa Wiggins. She was the co-author of Alcohol and Drugs in the Canadian Workplace for the 1st edition, and then declined to assist me and maybe do the hard work for the 2nd and the 3rd. But Elsa and I also had the privilege of being involved as counsel for an intervener at the Irving, Pulp, and paper case, which deals with drug testing and alcohol testing. We'll talk about that in a minute. So the book is comprehensive. This brief webinar is going to touch on some of the key issues, but not all of them. And so I'd encourage you to take a look at the book. You can look at it for 30 days free, I'm told, by LexisNexis. So order a copy, get it shipped to you online, and then take a look and see if it can meet your needs. So let's get into what I'd like to cover today. First of all, I want to talk briefly about workplace or occupational safety and alcohol and drugs. And we're going to talk about the change in the landscape with the legalization of recreational cannabis in Canada. Then we'd like to talk about managing the risk of impairment and or being under the influence of alcohol or drugs on the part of workers when it's employers who have the legal duty under health and safety law to make sure the workplace is safe for everyone. Then we're going to talk about the human rights implications and look at the 2 key ways that the disability prohibited ground of discrimination in human rights law can be addressed, and also the obligations employers have to have that duty to accommodate. Lastly, we want to talk briefly about a fitness for duty policy and the direction that is taking through safety sensitive positions and workplaces across Canada. So welcome to the webinar. Get your questions ready. Here we go. Alcohol and drugs effectively have no role in the workplace, but we have a poll question. Do you use cannabis in any form? This is anonymous. We're not reporting the answers to your employer. Please just tell the truth. So notice that the verb tense in the question is current use. Some of us may have to answer differently if we're looking at our far or distant teenage or college past. So interesting, we have 76% saying no and 24% saying yes. Well, thank you for answering that. Pardon me. And we're going to take a look at what other surveys say. So about 44% of Canadians over their lifetime have used cannabis, and about 12% on average used it in the last year. So if we took the current use to be within the last year, you have a slightly higher usage rate among people attending the webinar than the Canadian average. Interesting, and let's move on. All right, oops, moving on too quickly. So a health and safety law in its provincial and its federal counterpart under the Canada Labor Code makes it very clear that employers have the primary duty to ensure a safe workplace. Workers also have duties to follow employer policy and to not put in danger any of their co-workers. That's critical to keep in mind. Also, under the Westray bill, there is a criminal code duty for employers and all workplace stakeholders to take reasonable steps to prevent bodily harm under the criminal code, often referred to as the Westray bill. So these laws can result in large fines for corporations, penalties for individuals, and even jail time. So a safe workplace, when it's compromised by somebody being impaired or being under the influence of alcohol or drugs, is a serious legal liability risk for employers as well as for workers. It could be a matter of life and death. So health and safety at the workplace should not and cannot be compromised by workers impaired or under the influence of alcohol or drugs causing harm to other workers. The Ontario General Contractors Association, and they're one of the three interveners that I represented in the Elk Valley coal case that I'm going to talk about in a few minutes, issued the following statement several years ago. It's our experience that abuse of substance is a growing issue in workplaces, construction workplaces, and the legalization of cannabis will significantly increase usage, leading to a spike in workplace injuries and fatalities. Last September, I was at a conference in Ottawa, an international association dealing with alcohol and drug testing. One of the presenters on data collected from Canadian sources alone indicated there was a 40% increase around the month October of 2018, when cannabis was legalized, a 40% increase in the number of positive tests of workers testing positive for cannabis, or more accurately THC, tetrahydrocannabinol, the active psychoactive ingredient in marijuana and hashish. So a 40% increase is probably even more than the Ontario General Contractors Association were concerned about, but it's a serious concern for all workplaces, construction and any other that involve heavy industry and safety sensitive work. So let's take a brief look at the law with respect to cannabis being legalized, and we're going to look at that in a moment, but the question becomes, and I'm sorry, I think I went too far. Sorry, do we have another poll question? We do. I'm sorry, did I close it unintentionally? All right, I can't see the poll question coming up on my screen, but there it is now. Can you work safely on cannabis, or can you work safely if you're consuming or have recently consumed cannabis? What do you think? Please give us your answer, and then we'll have the automated response. So we have 28% saying yes, interesting, 72% saying no. 90% of cannabis users, when polled, say they believe they can drive their motor vehicle or conduct themselves at work, even in a safety-sensitive position. 90% say they can do it as safe or safer under the influence of cannabis. However, every international study says no worker works safer and all workers work less safe when under the influence of cannabis. And it's not even a question of impairment, it's a question of degree of effect on your workplace. That poll is interesting because there still is a common belief out there that you can toke up before you go to the construction site or before you go to your plant, or if you're the accountant, before you do your numbers, and still perform at a high level. But every study, Canadian and international, says that's a complete misunderstanding of the truth, and you will always have an adverse effect from even a small amount of illegally consumed, from a threshold point of view that we'll look at in a minute, cannabis. So what cannabis does, among other things, it does three things. It reduces inhibitions. It affects gross motor coordination. And thirdly, perhaps most seriously, it reduces the ability of cognitive processing of risk. That's a pretty bad trifecta of effects on judgment, coordination, and risk assessment. And if you don't believe me, well, then talk to the federal government. The Liberal government legalized cannabis back in 2018. Look at the Health Canada guide to the effects, both short and long-term, on cannabis, and you'll find I've just quoted from the federal government. So the same government that brought you legalization, and we're not going to get into that political or policy debate, is telling you what I've just told you. So keep that in mind as we go ahead. So medical marijuana, or cannabis, has been lawful for medical authorization from doctors since the year 2000. That was resulted from some litigation on the subject, and then federal approval and regulations. That's really not what we're talking about. However, if you have a worker with a medical authorization, they need to be able to produce it to you, and then you need to assess from their medical professional, are they still fit for work on a safety-sensitive position? There's an example of that later in the presentation that may be interesting to you. From a recreational point of view, we've got two levels of legislation. Federally, it's taken out of the criminal code, taken out of the Substance Abuse Act, federally, and legalized. And for regulation and taxation, and to some extent workplace interaction, recreational cannabis is dealt with directly by the two statutes, the Cannabis Control Act and the Smoke-Free Ontario Act. Then the third, tertiary layer of legislation is governed by the Occupational Health and Safety Act and also the Human Rights Code. So we know October 17, 2018, recreational cannabis became legal. The floor that the federal government set is the age 18. Most jurisdictions that have an alcohol consumption minimum age, like Ontario, with the age 19, have upped the year to the year 19. Where you have a disconnect is some provinces actually permit purchase and consumption of cannabis before you can actually drink alcohol, which is interesting. Provincial health and safety laws, though, and the federal Canada Labor Code, interesting, were not amended. So there is nothing, literally nothing, that's been changed in health and safety laws, even though recreational marijuana has been allowed, and for over almost 2 years now, and the consumption has clearly increased from the study that I quoted from. So what's an employer to do? You've got a high duty to keep the workplace safe. Workers that go to work don't want to have a stone worker beside them impaired, whether it's for medical purposes, as this slide indicates, or for recreational use. But the problem is we have some challenging court decisions that I'll take you to in a minute about how you deter and detect people from consuming a legal drug like cannabis, or other illegal and perhaps more serious drugs like heroin and cocaine. Medical use on the past slide and this slide is permitted, but it's restricted. So we don't have the Wild West. Not everybody can just access it for medical use. It has to be managed through our healthcare system and approved appropriately. Now, when the recreational cannabis laws were brought in 2018, the criminal code was amended. So I've often had questions saying, well, they're often telling me as if they know the answer, even though they asked the question. Well, there's no way to tell about impairment for cannabis, is there? Oh, there's none. Well, sorry, folks, that's not accurate. The federal government has amended the criminal code, so there are two threshold levels of impairment. One between 2 and 5 nanograms of THC actually creates a criminal offense that we call a summary conviction offense. So you won't go to jail likely for that offense because it's a lower threshold. However, if you have more than 5 nanograms, and this is typically by a Drieger 5000 device being used by a drug recognition officer, police officer at the side of the road or back at the police station. If you have more than 5 nanograms, then it's a hybrid offense. And so what we have is we actually have an impairment level that at and above that level is a criminal offense that could be indictable and often is if somebody's harmed or worse. So the penalties could be just a fine or they could be imprisonment. But there has always been, in addition to impaired by alcohol, well before these amendments in the criminal code, an offense where you can go to jail for up to 10 years if you're impaired by alcohol or drugs. Proof of the impairment's the issue. Drug recognition officers are trained to recognize them, but there is also now the testing technology. Is the technology perfect? No. Can it be challenged by a smart criminal defense lawyer? Possibly, if it's a borderline case. But typically, these impairment levels that set criminal code standards are serious, are real, and not to be ignored. So the question becomes, can they apply in the workplace, and how do you affect testing? Well, we'll get to that in a moment. Right now, just want to remind you that for Ontario, these are the rules. They're set under the Cannabis Control Act. You can't consume cannabis in a boat or a motor vehicle. And you can't operate it when it's open and available just the same as alcohol. So Ontario, as most provinces have done, have treated in many respects cannabis, even though it's legal, similar to alcohol, which of course has always been legal in Canada, never had a prohibition era here, like in the US. And so just because something's legal doesn't mean you can do it everywhere all the time or to excess. And that's the key message in some of your employee assistance program or other information you want to maybe provide to your employees when you're helping them understand that a workplace free of alcohol and drugs is a safer workplace. So the Smoke-Free Ontario Act brought in some further and additional regulations about when you could use and consume cannabis. You cannot consume cannabis publicly, even though it's often done. You cannot consume cannabis in the workplace, period, full stop. That's a Smoke-Free Ontario Act violation. It will get you a ticketed offense, not a criminal offense, unless of course you're driving a motor vehicle for your work. But what you need to do then from an employer's perspective is to realize you have every right, in fact, you're required by law to prohibit and to stop people from breaking the Smoke-Free Ontario Act in the workplace for not just smoking or vaping, but also toking, as the old phrase was used when I was growing up, consuming cannabis in any form, not just through smoking a cigarette. So those are some of the rules that need to be embedded in your health and safety policy and in your fitness for duty policy. And we deal with those in the book at greater length than we have time here. Highway Traffic Act also was amended to allow for the provision of legalized cannabis, but of course it's illegal to consume or be under the influence of cannabis when you're in a motor vehicle, period, full stop. And if you're a younger novice driver, you can have zero tolerance, quite apart from just the criminal code thresholds that we looked at. And there can be regulatory penalties of a suspension of license or a fine. So we do prohibit the consumption of alcohol and cannabis, a legal drug for recreational purposes, in the Highway Traffic Act, in the Criminal Code, and the Smoke-Free Ontario Act. So what have you done in your workplace? Have you acknowledged these prohibitions and limits? And is that reflected? Most employers like the idea, if they have safety sensitive positions, are essentially having a zero tolerance policy for alcohol and drugs in the workplace. Now, that should apply to the boss as well as workers, so there needs to be consistent messaging and consistent examples of behavior, but that's key because the consequences of being under the influence can lead to accidents, can lead to harm, can lead to one worker injuring or killing another worker, and that's absolutely unacceptable. Employers are held responsible if that happens. So when there's a policeman pulling over a driver who works for you and you're a courier company, they're going to take the driver, a drug recognition officer will take the driver through a 12-step process for impairment. That information is available publicly online, and we're not going to take you through it all, but they're going to take a look at coordination, samples of bodily fluids, and then charges may be laid. The question becomes, are you doing that in the workplace? Do you have that expertise? And the short answer for most employers, even in dangerous workplaces, is no. And do you have to sort of treat people in a policing fashion? Well, in some sense, yes, but in another sense, I recommend no. It's just not appropriate for people to be consuming or to be under the influence of alcohol or drugs at work. So you shouldn't really have to have a testing procedure. But if supervision, management sees or co-workers see a worker under the influence of alcohol or drugs and they are in a safety sensitive position, there is a duty on that worker to report the concern to the employer. Otherwise, there could be a safety violation by that worker. Determining impairment is not just by testing, whether it be breath, oral fluid, or blood testing, which is the most reliable, but it can be by observed behavior. This is critical to be aware of because one of the 5 potential thresholds for when you can deter and detect through testing is, according to the Supreme Court of Canada in the Irving, Pulp, and Paper case, when there is objective or observed evidence of impairment. So you need to train your supervisors on observed behavior that would indicate drug or alcohol impairment at work. And there should be a discussion after observation of the worker. There should be verification, because you don't want to prematurely judge people and send them home or discipline them if they're breaking your rules without actually assessing objectively, is there a problem with the worker? Often privately discussing the matter, asking the person, did they take any substance that might affect their performance? If they did, what is it? Why do they do it? Is it medically authorized? Just finding out what's going on. Not rushing to judgment, getting some legal advice before progressive discipline is charged is always recommended. So this detection through testing and then using testing as a deterrent is a very interesting and controversial subject, especially in Canada. We have never had a commitment to war on drugs like in the US. And so we've asked another poll question before we get into the law on this subject. Do you think that being high or under the influence from cannabis has the same effect as alcohol? Your comments and your answer here is very much appreciated. So some people think, well, I'll read the question again. Do you think being high from the consumption of cannabis has the same effect as alcohol? People are saying yes, 43%, no, 57%. Well, in the context of this presentation, I think the answer yes is the correct answer. However, are they the exact physiological and experiential sensations that somebody drinking alcohol or being high or under the influence of cannabis? The answer is no. But the effect, and that's the word that's key there, the effect is essentially the same. In other words, it's quite well proven and established that being under the influence of cannabis will impair your ability to work safely, just as alcohol. However, your experiential assessment of that, drinking alcohol, being impaired under the influence of cannabis, will be different. But the net effect from a safety perspective is essentially the same. Again, not to debate that, because if you're a heavy user with cannabis and or a heavy user of alcohol, you might want to argue with me. Don't argue with me. Don't argue with the science. Look please, at the Health Canada website, and it will give you the short-term and long-term effects of cannabis and the effects of use of impairment. They are, from a workplace health and safety perspective, essentially the same as impairment from alcohol. So let's continue then and look a little bit more at this detection and testing. So in Canada, there is no legislation for testing anywhere. We don't and didn't, when we legalized cannabis, address that issue. My opinion, that was an opportunity missed by policymakers and politicians in Ottawa and across the country. However, Canada is a highly unionized country relative, say, to the United States. We have a much higher percentage of our workplace unionized, and there's a significant union lobby in Ottawa and its provincial parliaments. And there's a lot of union members who vote who are led by their leaders. So that was a lot of the reason why earlier plans to set limited testing legislation were abandoned for political reasons, not for safety reasons. So what do? Well, we have to look to employment, privacy, human rights, and other case law to glean or to get the principles that you're going to have to struggle with to apply in your workplace. The starting point for testing as a deterrent is the Irving, Pulp, and Paper case. That's a case where Irving, Pulp, and Paper had a number of serious accidents over a number of years, and that were caused primarily by workers being impaired by alcohol. So they introduced a random program where 20% of the workplace randomly, independently administered, would be tested for alcohol impairment. Alcohol impairment is clearly measured under the criminal code at 0.08 milligrams per 100 milliliters. So that test in the criminal code is clearly a test of impairment. Arbitrator said, no, you know what, you got to prove you got a bigger problem, that people are being hurt or killed more than the injuries you've told me about before I'm going to let you do that. So the arbitration board said, no. Let me just pause there. That reasoning is troubling in the extreme for two primary reasons, maybe three. Number one, to wait until there's more accidents and death before you use an effective means of deterrent and detection, i.e. testing randomly, is a macabre legal principle. And it's directly contrary to the duty of an employer under occupational health and safety legislation in New Brunswick and all across Canada to keep workers safe. It's just macabre. It's waiting for more accident and death to happen, so then you can now do the testing. The other principle it ignores is that every study anywhere in the world has clearly said when you introduce random alcohol and drug testing, the likelihood of use or the actual use goes down at least instantly by 50%. So the evidence is clear that a random alcohol and drug testing program reduces the likelihood of impairment and use of alcohol and drugs. That evidence was available to the Supreme Court, but they chose to downplay it. They pulled from their own personal view, the majority did, a sense that there was a lack of evidence or insufficient evidence of any, quote, safety gains from a testing program. So the evidence was there to show testing programs always reduce use and therefore risk, but that didn't carry the day in the mind of the court. Now, there was a dissent. I'd like to think when I was arguing for the Canadian manufacturers and exporters as an intervener in the Supreme Court of the Irving Pulp Paper case that I influenced at least 3 judges, including former Chief Justice McLaughlin, who had a nice question for me that I answered, I thought, quite appropriately, and we had a good exchange. So at least 3 of the judges listened to the position of the employer and the intervener that I represented, but the majority said, no, random is presumptively not lawful unless you have an extreme, out of control alcohol or drug abuse culture. Again, that's kind of interesting logic, given that having a random program will in fact deter the use of something that could harm another worker. So legislatively, no rules. The courts and the principles, case by case, are how we deal with this. The court did deal, and I'm glad about this, with the 5 different types of testing, alcohol and drug testing available. Conceptually, Canada and other countries recognize that there are essentially 5 ways or circumstances in which testing can take place. First is pre-employment or pre-site access. Second is reasonable cause. That's where there's objective evidence. Fourth is you've had an incident, an accident, injury, or worse. The fourth is random. And then fifth is rehabilitation or last chance agreements. And we're going to go through each of them briefly. But 3 out of the 5 were approved by the Supreme Court. Now, some people don't know this. Some people think, oh, can't do any testing. It's all illegal. That's incorrect. The law is clear that 3 are not problematic. 2 are not absolutely banned, but are problematic. And I'll explain what I mean in detail in a moment. So pre-employment testing has been allowed in some cases, especially when you have cross-border transport, because they have to comply with American DOT, Department of Transportation regulations. So if you are applying for a job that takes you as a driver to the US, you're going to get tested. And for some reason, access to do your job into the US where testing is mandatory is a bona fide occupational requirement, i.e. compliance with American laws. And in other cases, if you're not internationally required to apply with or comply with American laws, it is not legal, even if you're doing something even more dangerous than driving it. So we're a bit inconsistent, to say the least, in pre-employment testing. But if you've got a strong commitment from the employer and you've got a safety-sensitive position, even if you're a contractor going into an oil sands project, you can't necessarily assume that you're going to be allowed. The best way to deal with this is negotiating. The Suncor litigation eventually was resolved by negotiating rather than the endless years they had spent previously litigating. So that's one of the takeaways, and I'll come back to that in a moment. So pre-employment testing, sometimes allowed, sometimes not. You need advice depending on your industry, your collective agreement if you have one, and your circumstances before you take that on. Second, reasonable cause. If you have trained supervisors and they detect a worker staggering around with bloodshot eyes saying, hey, it was a good bender last night and I had a chaser of, cocaine this morning, and their evidence tends to reinforce, or their behavior tends to reinforce that comment, then you may very well have reasonable cause to test. Now, you have to give advance notice of the testing. You have to have a testing program. We recommend a third-party medically approved testing laboratory, and there are several good ones that provide that across Canada. But if you're in a remote workplace, this sometimes becomes an issue. But the Supreme Court said very clearly that you can, with reasonable cause, in other words, objective evidence, test somebody for alcohol or drugs in your workplace. Third category, post-incident. This is basically the Elk Valley coal case. A worker working at an open pit coal mine was driving a very, very large truck that was a safety sensitive position by anybody's standard of what that means. Went to a party, consumed a undetermined amount of snow or cocaine. And then when he had his 1 or 2 hours of sleep before he went and did a shift, he took the edge off repeatedly, according to the statement of facts, by smoking a marijuana cigarette or 2. So he comes to work, he's under the influence of cocaine and cannabis, and he has an accident. Thankfully, nobody's killed. There's only minor property damage. However, under the policy of Elk Valley Coal, they tested him. And surprise, surprise, he tested positive. Before he could be disciplined, and that's the second part of the story that we'll get to in a minute, the worker shows up with his union-approved addiction counselor saying, I'm sorry, I didn't realize that I was addicted to cocaine. So we'll continue that story in a minute, but what they did not dispute, what the union did not dispute, or the worker did not dispute in that case, was that it was lawful to test. It is. Post-incident testing approved by the Supreme Court of Canada in Irving, Pulp, and paper. Return to work. So this is number 5 in my original list. So if you have an employee with a drug or alcohol problem, perhaps you fired them, perhaps you've gone to arbitration, or perhaps you've negotiated the situation and you're prepared to take them back if they take their problem seriously and agree that they're going to be clean and sober and not come to work under the influence, you may have what's known as a last chance agreement. The last chance agreement may give you the right to randomly test or to have the worker go for a period of time, anywhere from 6 months to perhaps 2 years, to get rehabilitation, but also to be tested to make sure the rehabilitation is working. So that usually is on an agreement between 3 parties, the employer, the union, and the worker, and that's been approved and is lawful according to the Supreme Court of Canada. So the big one, of course, the controversial one, the one that is the subject of ongoing litigation, is random. Random is unannounced testing for alcohol and drugs, and it has the most safety gains by all studies that have looked at random and non-random testing. And yet, because it's random, because people get caught when they're doing something that's in violation of the company policy and arguably breaking occupational health and safety laws, it is the most hard fought by workers, by unions, and their legal representatives. So random only, in my view, should be considered if it's in a safety sensitive position. However, we don't have a definition. There is no legislative or government passed law for a safety definition. So you have to define that, because you only want to be randomly testing people, in my opinion, who are in a safety sensitive position. So you've got to look at it, you've got to assess it, and I've got some points on the slide that give you some direction. Though in the book, we deal with the safety sensitive issue in considerable detail, and there's some language there that might help you. So the big case still out there is the 2017 court decision, even though it was an interim injunction in the TTC matter. The Toronto Transit Commission, running the largest transit authority in Canada and the fourth largest in North America, has had problems with some of its employees coming to work under the influence of alcohol and drugs. There have been some accidents. In fact, one pedestrian was fatally injured, from what I recall, that led to this approach. The matter was grieved under the collective agreement, but the arbitration, which has now been abandoned and restyled, and I understand is going to be going forward soon, was not moving ahead quickly. And the TTC, the employer, said, well, this is just terrible. I mean, we've had another accident, another worker impaired. We really need to show leadership in this. So they implemented the random policy. The union responded. Local 113 of the Amalgamated Transit Union said, well, we're going to go to court and stop you from doing this. And Justice Morocco, very experienced, very capable judge, heard arguments and ruled against the union. He said there was not a prima facie case, they're not likely to win, but in the balance of convenience, safety trumped privacy and sensitivity rights. So this is interesting. This is the first and most important decision in an Ontario court about random testing. The TTC program was put under careful scrutiny. Somebody who I count as a friend was one of the experts for the TTC, and who was a doctor who gave very compelling evidence and wasn't even challenged on cross-examination by the union. And the end result is that because the TTC took a cautious and high threshold level, so they have an oral fluid testing policy for cannabis, the 10 nanograms was the cutoff, higher than impairment. So a person would be impaired under the criminal code, but if they were below 10, that would be considered a negative test. They were very fair and very cautious to their workers, but saying, look, when you're testing at 10 or more nanograms per milliliter, you are clearly by criminal code standards impaired, and we can't have that. So that cautious approach, but a comprehensive approach, means that 20% of TTC workers, including all of management, get tested randomly. They can ask for the B sample to be checked if the A sample tests positive. The medical review officer under the program will confidentially talk to the worker without the employer know about it. Is there a medical authorization? Is there anything you want to talk to me about, what you're doing, what you're taking, to maybe help me overrule the test and say it's a negative rather than a positive. And then the other important rule is that if you decline to take the test when your number literally comes up, then that's considered a positive, because obviously if somebody's impaired and they don't want to be tested, you can't let voluntary withdrawal from a random test be acceptable. So all of that resulted in the random program being accepted. And the court really emphasized that the safety not only of workers, but also of the public was at stake. However, the thing that's distressing about many arbitration cases that distinguish the TTC case is the issue that it seems that when you have the public at risk, like in the TTC case, you can do random alcohol or drug testing. But if it's just workers at risk, my goodness, we don't seem to care as much. So therefore, they, in many cases, and there's a recent one from out west, and there's the Sarnia Construction Association case, that really kind of overthink the issue, in my opinion, and say, no, the problem's not bad enough yet. So no, you can't do random testing in that particular area under that collective agreement. So the litigation continues. The lack of leadership by politicians on the issue continues of alcohol and drug testing. And, I'd recommend you get legal advice, that you're cautious if you're keen to do random testing, because you likely will have to litigate the issue unless you can get the consent of the union in a unionized workplace. So let's transition and do the second half of the Elk Valley Coal story. So human rights and human rights legislation apply in effect, because you can have a disability. And if you have a disability, you cannot be discriminated against by your employer because of the disability, directly or indirectly. So that sets up the discussion. So you can have a disability of being a drug addict. Some people think, well, I can't be addicted to cannabis, can I? Well, again, without being a medical authority, I can't give you a medical opinion, but I can, again, direct you to the federal government's Health Canada website that says, yes, cannabis is addictive. It's not as addictive as cocaine, but it's, addictive. And that's a medical fact. So a person can have a disability of being addicted to cannabis and use it, and then you may have an obligation to accommodate that disability. Another way a disability under the human rights legislation may apply is that you have an underlying medical problem, a condition that is a disability, that you have a medical authorization to have cannabis as the treatment. So in either category, the human rights legislation engages. However, if you're a casual user and you absolutely take the position, no, this is not for medical reasons, I use it recreationally, cannabis, and I'm not addicted, I'm absolutely not addicted, and you don't really want to have an addiction counselor say you are, then you really don't have a human rights issue to litigate. So let's go back to Elk Valley Coal. So our friend, Mr. Stewart in Elk Valley Coal, consumed cocaine, consumed cannabis, had both immeasurable significant levels, and came back to the employer and say, well, before you make a decision about whether I have a job or left or not, after I've had a motor vehicle accident and there was some property damage, I want you to know I've just realized, I've been shocked to realize, but my addiction counselor in the accident helped me realize I'm a cocaine addict. Okay, dilemma. So he's got an addiction. That's a disability protected by human rights legislation. Can you discipline up to and including discharge? Well, the employer looked at that and they said, well, wait a second. We have an employee assistance program that would have allowed you to get help for your addiction, assuming that's true, if you wanted to. Say, and every addiction counselor will tell you, the person's not going to get better with the addiction unless they actually choose to get help. So you have to have an engaged and willing addict to get help from the addiction. Secondly, the employer said, look, we have a policy that says you've got to self-report and get help for your addiction, but if you don't and you have an accident, we have a no free accident policy. That's sort of just a summary of that policy. In other words, we say, look, if you have an accident and we test you for alcohol and drugs and you're positive, that's it. You've broken the rules. You knew the rules. You signed on to agree the rules, and you've broken the rules. And the human rights argument is not going to fly. Sorry, we're letting you go. We're terminating your employment, Mr. Stewart, Elk Valley Coal said, not because you're maybe addicted or not addicted. Well, we're not dealing with that issue right now. We're dealing with the fact that you broke the safety rule and you were impaired and you knew that was an offense that we could terminate your employment for. Well, that got litigated at the Human Rights Tribunal in Alberta at 2 levels of court in Alberta, and it ends up in the Supreme Court of Canada. The Supreme Court of Canada decision is interesting because there are 3 different sets of reasons. One, dissent, single judge. The second a majority that said, no disability here, and then a majority in the majority saying, yeah, there was a disability, but the method of accommodation in a safety-sensitive position was adequate. So the Moldaver majority of the majority, as I call it, was and is the most interesting and probably important for employers to be aware. It kind of makes the point that you don't have to accommodate somebody who signed on to a safety sensitive position, was told that you can't do drugs or alcohol or be under the influence at work, was told that there is an employee assistance program if you have a problem and your job will be protected, but you have to self-disclose. And also that if you have an accident, you're under the influence of alcohol or drugs, we're going to discipline you depending on your circumstances up to and including discharge. So in effect, and this is my language, not so much the Supreme Court's, they were preemptively, before the accident or pre-accident, providing an accommodation of the potential disability of any worker that might say, hey, I'm addicted to alcohol or drugs or both and need help. In other words, you can't wait till there's an accident or an injury or a death to then invoke your disability status. And so I think that decision, and the majority decision generally, is very sensible, a breath of fresh air, and ironically being ignored by a lot of arbitrators. So if you're in a case right now or you want to improve your policy, take a look at, get your legal advisor to give you advice on Elk Valley Coal. Because if it's a safety sensitive position, if you have an employee assistance program, if you have a zero tolerance policy, and you want to clearly indicate you don't get a free accident before you are going to potentially be disciplined, then Elk Valley Coal will give you a template to work with. That's not to be harsh with employees who have true addictions. Employee assistance programs are a great idea for employers to have, but it's to protect other workers from somebody who's impaired by drugs or alcohol and may in fact have caused harm, serious harm to another worker in the workplace. So another example is the self-medicating. I didn't really have a medical authorization, but decided to use cannabis for my chronic pain case of L&L painting. This gentleman was found smoking on a platform about 37 floors outside of a high rise. And that was said to be, yes, not a good idea. Even if there was a disability that the marijuana was used to treat, you still can't, in a safety sensitive position like that, think you can self-medicate, you can break the employer's rule and complain that you're being discriminated against because of your disability. In other words, you may have your job protected if you self-disclose. There may be a need for employers to accommodate to the point of undue hardship if you've got either chronic pain where cannabis is needed to treat the chronic pain, and or you're addicted to marijuana and that's an addiction that you acknowledge to your employer. All of that's fine and well and good, but if you're breaking the rules and you haven't got the approval of the employer to be doing the safety sensitive position while under the influence of alcohol or drugs, then L&L painting says no go, you can't do that. You can discharge that type of employee in that circumstance, and that's a human rights tribunal saying that. So final wrap up, couple of slides, and then we'll go to fitness for duty. But first, does your employer have a fitness for duty policy? Yes or no? Don't know if people are able to vote. I can't see the voting on my screen, but perhaps it's there. Okay, there goes the poll. It's up. Does your employer have a fitness for duty policy? Now, some of you might be in charge of putting that together. So this is anonymous. Nobody's keeping track of your organization or you. Let's just find out honestly whether you have a fitness for duty policy or not. And a policy that's called a fitness for duty policy. And the results are, well, that's encouraging, sort of. 35% say yes, 65% say no. Wow. Well, I'm a bit facetious when I say it's encouraging. You may have an alcohol and drug policy. You might have some sort of code of ethics policy that deals with, prohibiting drug or alcohol use in the workplace. I really want to encourage you to think about fitness for duty for three reasons. One, it is a more positive concept, being fit for duty, that workers, union, and management can all agree upon. Nobody wants a worker not fit for duty, and it might be extreme fatigue. It might be emotional and mental distress that you bring to work. If you're not fit to do a safety sensitive position, what are you doing there at work? If you need help, get help. If you need a break, get a break. If you need that vacation or if you need sleep, get it. If you need help getting off alcohol and drugs, get the help. But don't bring that problem to work, not because nobody cares that you have a problem, but because you're maybe or likely putting other people at risk. The Metron construction case, tragic Christmas Eve fatality case, 4 workers died. 3 of them, including the working foreman, had measurable impaired amounts of cannabis, and one of them had alcohol as well. 4 workers died. One is in a wheelchair for life. And that's one of many, many examples. And look, employers, it's not as simple as saying, well, it's the worker's fault. They're drunk. They hurt themselves or hurt someone else. Metron was prosecuted criminally. The superintendent was charged and prosecuted and convicted criminally. The supplier of the scaffold was prosecuted under regulatory occupational health and safety laws. The risk, the legal liability at a corporate and an individual leadership level is huge. So don't take the chance for the sake of the workers, for the sake of your liability, and because it's the right thing to do. So why a fitness for duty policy? Well, because everybody can get onto that idea. Nobody wants a worker who's working beside them to be unfit and causing themselves to be at risk. So fitness for duty is a concept you can buy into. Also, it emphasizes the positive, the fitness, rather than negative impairment by drugs and alcohol. And third, it helps you then define and explain and enforce rules about why you can't be at work under the influence of alcohol or drugs and why it's a bad idea. And then you can build out your prohibition against it, your testing rules if you have them, and the consequences for breaching the rule. So fitness for duty is a much more progressive and positive approach that hopefully unions, workers, and management can agree upon than a simply don't do drugs, zero tolerance, we're going to fire you if you are under the influence type of approach. We list a number of factors on slide 40 and 41 that I'd like you to look at. If you've got a fitness for duty policy, look at the elements that we think should be covered. And if you don't cover some or all of those, you've got to buy the book because we've got a detailed fitness for duty policy easy for you. Now you can call me and hire me and we can help draft the policy for you, or you can buy the book. It's a little cheaper than my hourly rate. But the point is, look at the list. We've worked at this. We've done a lot of good drafting, a lot of preparation for clients. They're happy with the results. And this list, as well as the others, are the issues that we think a comprehensive fitness for duty policy should follow. It might need more for your workplace. You might have nuances that you have to look at, but please take a look at that. So we're going to wrap up soon. It's been fun. There's a lot of material that we haven't been able to go into much detail on. I can assure you the case analysis is in the book, the fitness for duty model policies in the book, and you don't have to listen to my voice. You can read my words, and that might be more enjoyable. Listen, do we have some questions, Monica, that we have time to deal with in the 5 or 6 minutes that we have left?
Yes, thank you, Norm. We have some great questions coming in through the chat. Since legislation has come into effect on October 17, 2018, do you know if employers have had to send people home for appearing to look high? And if so, could the employer run the risk of a complaint from the Human Rights Tribunal if in fact the employee was not high?
Yes and yes, but to be more helpful and amplified, employers are regularly sending workers home or complaining to unions if they're unionized if they appear to be high. It's a hard judgment to make. You have a right to test if there's objective evidence of a person being high or under the influence of cannabis. It's not always easy to tell. One of the things we will always recommend is you ask the employee. If the employee refuses to answer, or lies to you clearly, and there's other evidence, then you have other credibility issues. Can you be filed with a human rights complaint? Absolutely. And that's why you need a fitness for duty policy. If you've rolled out the policy properly, if you've given an educational component as well as a disciplinary component in your training on the fitness for duty policy, you should, like L&L paving, survive in a human rights complaint. Next question.
Great. In your experience, how often do employers face drug, alcohol, or cannabis-related issues in employment? And is there a method an employer can use to screen potential employees for such issues? And would that be deemed discriminatory?
Well, I think I've already answered the last question. It won't be discriminatory if there's a clear policy and the policy is part of the terms and conditions of employment. The frequency and the continued use and increased use of cannabis is an ongoing problem. The World Health Organization has identified Canada as the highest per capita user of cannabis in the world. We've legalized it. We're the second country in the world to legalize it across the board. Although people think, oh, gee, well, it's legal in Amsterdam, isn't it? Well, no, it's legal in marijuana cafes in very limited districts, and it's often more of a tourist thing. A lot of locals don't even like it. But is it widely and recreationally available like it is in Canada, in Amsterdam? The answer is no. So even some of the so-called liberal European countries like Holland aren't as liberal as Canada's. And that reflects both a demand. It was a politically popular move for the Trudeau government to bring it in, but also shows you that for reasons that I don't fully understand, there's a high percentage of use. And when you give the endorsement of legality, use generally goes up. So the net result is, yeah, there are people coming to work every day under the influence of cannabis. But it's not just cannabis. There's other drugs. And look, we've seen in the period of COVID increase in violent crime across our cities. We've had the increase of domestic abuse because of relationship and economic stress. In times of stress, you're going to have more of that. So this is a time to take this issue seriously. All I can say lastly is when I'm defending an employer, which I do a lot of for health and safety violations and somebody's been injured or killed on the job, there's an increasing number of injured workers or the people who have caused the injury to someone else who are under the influence of alcohol or drugs. So it's a serious problem. It's not going away. You need to engage in a fitness for duty policy if you haven't already. How about one more question before we give the gong and the final closing remarks?
How can employers be certain if someone is coming into work high? And can testing be spontaneous, or does there need to be notice of testing?
Well, I think we've dealt with the random or spontaneous testing, but spontaneous testing, that's an interesting word. I haven't heard that used for a while. That may be, in fact, legal. So again, just to recap, if it's random testing, it's likely not legal. That's Irving, Pulp, and paper. If it's for cause, there's objective evidence that the person might be under the influence of alcohol or drugs, then it is legal, but the program can't be sprung out of the bushes. It's got to be widely communicated. You can explain why to people you're doing it. You've got to have the infrastructure and the testing available because drugs and alcohol abate to varying degrees over time. So there has to be a timely testing program in place. But you can test, and you can also test post-incident, like in the Elk Valley coal case. So in 3 of the 5 types of testing, it's completely lawful, but it doesn't mean that you can do it unannounced in the sense that the program's not known and you just jump out of the bushes. That's why there was lots of dialogue, lots of effort to get consensus at TTC. When they couldn't reach consensus on the random testing part, then that matter was litigated. So my encouragement is think about the risk to your employees as the #1 priority to look at this issue. Next, think about the legal liability that your organization and its managers and officers and directors have. And thirdly, think about the reputational damage to your organization if in fact you have a serious accident or fatality and it's because you didn't manage this issue well. So alcohol and drugs in the Canadian workplace is an important and serious issue. It can be managed well, not perfectly, but well. And I think if you take a look at the book, you're going to get a lot of help to support you along the way. Or give me a call, send me an email, and I'll see what I can do. Thanks so much, Monica.
Thank you. And I just want to remind everyone that the recording and the presentation and any unanswered questions will be sent out in a follow-up email after today's session. And I would like to thank Norm for taking the time to speak to us today, as well as everyone who attended. Thank you.
Thanks so much. Take care. Bye-bye.